This is Radio Now 95.3 FM. Come for the news, stay for informed conversations.
A high court in Adamawa State has thrown out the case filed by suspended resident Electoral Commissioner Hudu Yunusa Ari, seeking to halt the proceedings filed against him by the Independent National Electoral Commission INEC. Mr. Hudu was suspended by INEC following his declaration of Aisha Binani Dahiru, the candidate of the All Progressives Congress APC, as the winner of the Adamawa governorship elections in 2023 before the collation of results was complete. Joining us this morning to explain the arguments on both sides is legal practitioner Justice Ojieno. Mr. Ojieno, good morning. Thank you for joining us on the conversation.
Good morning to you and good morning to our listeners all across the world. It's my pleasure.
Right. Can you give us a sense of the arguments preferred by INEC against Mr. Ari, as well as his counter-arguments against them?
Okay. Before I delve into it, I must give the clarification that you know that there's a limit to what I can say because it's an active case. But having said that, one major thing that the INEC prosecutors are saying is that Mr. Ari actually has to go through the full prosecution, and the full case has to run its course from the beginning to the end. While Mr. Ari is saying that, okay, there are some issues that need to be handled by the appellate court, especially the Court of Appeals, and subsequently to the Supreme Court. And if those issues are not heard by the appellate court at this moment, there's a tendency that if the lower court, the present court, continues with the case, the court might be in error. We call it essentially a stay of proceedings. But the challenge with the stay of proceedings is that before now, what defendants use it for is to stall cases and make cases linger to practically forever. When they know that, okay, a case has started at the trial court and it has gotten to 20% or 30% or whatever other percentage on the continuum, then they will ask for the proceedings to be stayed for the court to put whatever it is on hold until some questions are answered by the appellate court. And what the law did in answer to that stalling strategy of litigants is to, especially in criminal proceedings, pursuant to the Administration of Criminal Justice Act of 2015, was for the court to still consider the issue and rule on it at the end of the proceeding, so that all the matter, the entirety of the case, both the issues that are to be determined in the interim levels and at the conclusive levels, they are taken together at the conclusion of the case at the appellate court. Not that the matter, the issue will be treated now, while the matter is still ongoing, go to Court of Appeal, go to Supreme Court, then they will come back again to the trial court to continue it again until 60%, then go and argue the another issue that they raised again at the appellate court, at the Court of Appeal, then bring it back again to the High Court until they get to 90%. All the back and forth, they are practically made criminal trials last year, practically eternity. That is what the Administration of Criminal Justice Act came to do. So while the prosecutors are saying, sorry, this is not to be entertained, all the issues should be taken together now, and if there is any argument you want to have, let's argue everything at the Court of Appeal when the matter at the trial court is concluded. Mr. Ari's lawyers are saying, sorry, this issue is very, very important, and if the trial court doesn't get it right, it will change the entire case. So we should take it to the Court of Appeal. The trial court should hold on with whatever issues that they are dealing with the entire case. Let us go and treat this issue at the Court of Appeal and possibly at the Supreme Court if the matter gets, if they still feel that they want to litigate it to that point until. So that's just the essence of the back and forth. So that's the latest motion that Mr. Ari's lawyers did pass.
So, and you referenced this earlier, the state government, their counsel argued that, look, this isn't a civil matter, it's a criminal case. And because it's a criminal case, referring to the administration of criminal justice law, right, it says that you can't halt a criminal trial. So the matter of postponing it indefinitely is what is now being debated. I'm curious as to whether there are similar cases that haven't happened in the past where we could draw possible parallels, or how those cases have turned out, and if that would have any sort of bearing in terms of considerations by the bench that's overseeing this particular case.
Okay, as for particular cases, I may not be able to give you maybe by name now, by heart, but just know that they are up to 10,000, at least where the court has had to adjourn. Sometimes it says, if I have to speak another language, China die, or not be as whatever it is that we want to sound it. So that is for the court. It is adjourned in order to ensure that, because sometimes the trial court can actually make serious error in proceeding with a case if a particular answer is not gotten from a superior court at the interim level. But the challenge with that is that it was being abused. It was being abused by litigants to make a criminal matter last practically forever. But with civil court, it is a very, 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 even though it's still allowed, but it's a very, very rare occurrence, because now the tendency is for the court to allow for speedy dispatch of cases. Otherwise, everybody will file a stay of proceedings. Everybody will apply. Every lawyer on the face of the earth will apply for the matter to be adjourned indefinitely until the matter is completed at the appellate court. And it forms part of the reasons why we are having delay in the delivery of justice. The docket of our justices are too full, and that is why in criminal law and in criminal proceedings, the tendency is for the legislature to say that stay of proceedings should not be entertained for any reason whatsoever. Anybody that has any question should conclude their case and let the appellate court take it together. Not that the appellate court will have to determine this issue. It will have to go the entire hall, come back again, go the entire hall, come back again, go the entire hall before a matter is concluded. Right. So it is the abuse in the process that made that be the case in criminal cases, and even in civil cases too. The procedural rules of various courts, the civil procedural rules of various courts, largely discriminate against this kind of application.
Right. Well, Mr. Ojeno, thank you very much for your time and your expertise on the conversation. Justice Ojeno is a legal practitioner who joined us this morning to speak on a high court in Adamawa throwing out a case filed by suspended resident Electoral Commissioner Hudu Yunusa that sought to halt the proceedings which had been filed against him by the Independent National Electoral Commission, INEC.
This is Radio Now 95.3 FM. Come for the news, stay for informed conversations.